Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and continuing on with the 2021 changes to the Georgia Association of Realtors GAR contract package. Just want to finish up with the listing agreement. They're excited. And just, you know, there are a lot of changes. Please watch the other videos that I have done, and I do welcome your comments. But the remaining changes, I think I want to just finish up in this one video. So, and again, we do have CE classes on the 2021 GAR contract changes. I'll link the calendar below. They are virtual, they are free, and they are open to all agents throughout the whole state of Georgia. But let's continue on. Again, I am on the exclusive seller brokerage engagement agreement F101, and a lot of the changes are universal changes throughout the brokerage engagements. So one of the things that they added is under the marketing paragraph, they added a section that basically states the seller acknowledges that the buyers and other brokers may actually take pictures or videos inside the property. Are they supposed to? No, especially if you are an agent, do not take inside photos of somebody else's listing. You do not have written permission to do that. Nevertheless, it occurs, especially right now with a lot of the virtual showings that we're having. So under the paragraph B3 under marketing, there is a disclosure that says seller acknowledges that buyers and other brokers may take photographs, videos, and other technology to capture images of the property to assist in marketing the property and helping buyers remember different properties. Seller agrees to remove any personal property prior to listing the property with this, that the seller does not want those images captured. So just wanted to bring that to your attention. They've rearranged some of the paragraphs regarding commission and default. So there's nothing new content-wise, just a rearrangement of those things. Dual agency. Everywhere that it talks about dual agency, it is made more, GAR has attempted to make it more prevalent where it talks about dual agency under the agency and brokerage section, under what kind of agency that a broker allows, under no adverse agency relationships. The intent is that when the public signs these documents, they are actually giving informed consent to dual agency rather than implied consent to dual agency. So again, that is a universal change throughout all the documents where it talks about dual agency. Then there is a brand new paragraph, B8, negotiation in the listing agreement. And it states that while the broker may assist the seller in negotiating terms of a contract to sell, if the seller has elected to have the broker assist in this role, all decisions regarding price, terms, and other conditions in a contract to sell shall still be made by the seller. In other words, it is the seller that still has full control over the negotiations, even if they're allowing the agent or the broker to assist in those negotiations. They've added under the limit to the broker's authority and responsibility, they've added, again, in the brokerage engagements and in the purchase and sale agreement, a sentence about it is the public's responsibility to determine if the property has a propensity to flooding and if there are any flood zone certifications. We had, for whatever reason, we had a lot of issues this year with buyers purchasing properties and not finding out until they're at the closing table that the property is in a flood zone, and that does impact the premium that they pay for their hazard insurance. So their lenders should have found that out, and their homeowners insurance should have found that out, but it was discovered at the closing table with the title. So you agents working with buyers, make sure, even if you don't think the property is in a flood zone, make sure that the buyer checks that out before the end of the due diligence period so that the buyer, if they want to terminate based on that, will be able to get their earnest money back because they'll still be within due diligence. Under paragraph C6, the miscellaneous section, just a few changes here. First, they alphabetize everything, so that makes it a little bit easier to read. They have added the section under attorney's fees. That basically, if there is a dispute regarding the agreement in and of itself and it goes to court, the winner has to pay the loser's attorney's fees. So that is now disclosed in the agreement. And this was under definitions, but they've changed it around. But anywhere in the GAR contract package, when it uses the term broker, by extension, it also means you, the agent. It means the broker's affiliated licensee as well. And then there's a whole section under the GAR forms that says no party is ever required to use a GAR form, a Georgia Association of Realtors form. The parties can use whichever forms they choose to use. And then this is really interesting. They've added a whole sentence that talks about provisions in the GAR forms. This is paragraph C6G. Provisions in the GAR forms are subject to differing interpretations by our courts, other than what the parties may have intended. At times, the courts may strike down or not enforce provisions in our GAR forms as written. No representation is made that the GAR forms will protect the interests of any particular party or will be fit for any specific purpose. So just want to basically, that's any lawsuit, any case that goes in front of a judge. The judge is the final authority on the interpretation of whatever is written, whatever contract there is, whatever the judge feels the intent of the parties are. And so GAR is just putting that out there, that regardless of the intent of the parties, there are times when a court in Georgia and the judge could rule in opposition to what is written and what you think and what the buyer and the seller think that means. Another section they have added, this is a great section under, again, C6 Miscellaneous. There is a section under third-party vendors. As a broker, I always inform all agents, I don't care who your broker is, but as a broker in general, to all affiliated licensees, you always want to give more than one name of any particular service provider, and you're doing that as a courtesy, but the ultimate decision to select is your public person. So GAR has actually made that disclosure in writing in the brokerage agreements, and it does specifically state in paragraph O, third-party vendors. Broker may provide seller, this is the listing agreement, or the seller brokerage agreement, with the names of vendors to perform services on behalf of the seller relative to real estate transactions involving the seller. Broker does not warrant or endorse the performance of any such vendor, and the names of vendors are provided solely as a courtesy and as a starting point for the seller to identify possible vendors to perform services on behalf of the seller. The seller agrees to do his or her own due diligence regarding the skills, expertise, and reputation of all such vendors performing services for seller and the terms of all contracts with vendors, including whether there is a limitation of liability in such contracts. All decisions regarding which vendor to hire shall be solely that of the seller. And again, same verbiage in the buyer brokerage agreement, only it says buyer. There's another section they added under seller default. So this contract is a bilateral contract, meaning the seller and the broker must sign the brokerage engagement, and therefore it creates a contract. If the seller unilaterally terminates the contract, then it does constitute, prior to the expiration of the contract of the listing agreement, it does constitute a default. So what GAR has added under the default section, paragraph C8, and again, this used to be in a different place, it states that if the seller agrees that termination of the agreement prior to the end of this agreement without prior written agreement of the broker, in other words, it's a unilateral termination by the seller, that the broker or agent removing the signs, removing the listing from MLS services, or ceasing to market the property in any way does not constitute evidence of the broker's agreement to mutually terminate. In other words, it's still a unilateral termination even if the broker stops the marketing. That is not a sign of a mutual termination, and that would still constitute a seller default. And again, there are just some other changes regarding where various information is located. They've rearranged some of the paragraphs and so forth and so on. And then one other universal change that GAR has made above every signature line in all of the in the listing agreements, the buyer brokerage agreements, purchase and sale agreements, leases, counter offers, everything, is this new verbiage above the signature line. And it says, by signing this agreement, seller acknowledges, and obviously it's going to say buyer or parties, whatever, depending on what the form is. But in this, we're talking about F101, the exclusive seller brokerage engagement agreement. By signing this agreement, seller acknowledges that, number one, the seller has read all the provisions and disclosures made herein. Number two, the seller understands that all provisions and disclosures and has entered into this agreement voluntarily. And number three, the seller is not subject to a current seller brokerage engagement agreement with any other broker. So this is specific, again, to the listing agreement. You will read in the other ones that it has similar verbiage for the buyer brokerage, and in the purchase and sale and in the counteroffer, it basically says the parties have read the agreement, understand the agreement, and acknowledge and agree to what they're signing. So that's it for the changes in the listing agreement. There might be a few other changes, as well as the terminology, which I've addressed in a previous video, that universal change throughout all of the contracts for simplicity or clarity's sake is instead of referring to the broker working with the seller as the listing broker, it now says seller's broker. And instead of referring to the broker working with the buyer as the selling broker, it does now say buyer's broker. So those changes are also made universally throughout all of the forms. So we'll continue on. There are a few more changes to address, but that's it for the listing agreement, or I'm sorry, old habits are hard to break. The seller brokerage engagement agreement. Thank you guys so much for watching. I welcome your comments below. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.